On behalf of the Planning Committee and the District Court, we want to welcome you to this district conference. We are finally here. After 7,936 emails exchanged with panelists, I made that up, but it's in the neighborhood, and more subcommittee meetings than we care to count. We are swabbed, verified, and ready to learn from the inspiring array of local and national racial justice experts and practitioners here with us today. I know that both Josh and I have been humbled by the willingness of so many remarkable champions of racial justice to join us here in Rhode Island today. A few logistics before I turn it over to Josh to thank everyone we need to thank, and there are many of you. We kept it simple today. You don't need to walk around the entire hotel to find the venues for your panels. Everything will be happening basically in this space. After we have some brief opening remarks this morning, we're going to break into two panels. In the morning, we kept the panel duration long so that we could have a deep dive into these topics. So there's two panels in the morning, two in the afternoon. This morning's panels, as you know, critical race theory and diversity in the workplace. You've already made your election, so no FOMO, you signed up, you gotta go. This afternoon, we will have an award ceremony and our keynote from Mr. Gray. We're tremendously honored and excited to have him with us here today. And our own Judge Roger E. Thompson will be joining him for comments. And then in the afternoon, you've got qualified immunity and the role of the federal judiciary in civil rights and racial justice. And then we have a panel with the remarkable experience of having a direct dialogue with our entire federal court bench, a very rare privilege and opportunity for us here in Rhode Island. And then we will conclude with some libation and conversation at the end of the day. As we're going to hear in each of the panels today, federal courts play an essential role in the jurisprudence of racial justice. But I've been reminded over and over in the months of careful planning that lead to today that courts can only engage the cases that we as lawyers bring before them. So whatever your role is in your day job, and whatever the focus of your work in the law, throughout your career, you'll find opportunities to contribute to bringing cases before the federal court that importantly ask questions about racial justice. And we encourage you to do that. Part of the reason for bringing everyone in the room today, and we have a full house today. This conference was fully subscribed with over 250 attendees, which is kind of a record, honestly, for the conference. So we really encourage you to be looking and thinking and engaging these ideas for opportunities how you can become involved, whether it's pro bono co-counsel on a case, whether it's taking that phone call from a colleague who has a difficult evidentiary question in a case they're pursuing, whatever that might be, signing up for the pro bono panel in the federal court administered by Judge Sullivan. These are all ways that you can take the ideas that will be in the room today and act upon them. Because, sadly, history does not gravitate towards justice without work and struggle. And so today we're here to learn more about that.
Thank you, Jen. My name is Josh Xavier, co-chair of the conference this year. It's so great to see so many of you, and so great to see so many familiar faces. Thank you all so much for taking your time out of your busy schedule to join us today. So over the course of the last year, our conference committee has done diligent work in searching out for experts in various areas of racial and social justice. So this morning, we did want to take a few moments to thank each member of the conference committee. So each subcommittee session was led by a convener. So when I do say your name, please stand, and if we can reserve applause for the end, that would be great. Each subcommittee was led by these following conveners: Jennifer Wood, Danilo Borges, myself, Pamela Chin, and Zachary Mandel. Conference committee members include the following, and when I say your name, please stand. Lori Barron, Jonathan Cohen, Saikon Gbehan, Shauna Kurland, Lisa Jaramia, Amy Romero, John Marshall, Professor Nikki Kukas, Tim Baldwin, Melissa Horn, Zachary Cuna, Jay Dixon Acosta, Jose Batista, Chloe Davis, Samantha Vasquez, Eddie Lee Schaub, Adam Ramos, and Judge McConnell. Thank you all. This conference also would not have happened if it wasn't for the awesome folks from the federal court. So when I say your name from the federal court, please stand. Frank Perry, Jennifer Diaz, Honora Tyre-Witek, Judge McConnell, and last but certainly not least, this conference definitely would not have happened if it wasn't for Raina Smith. So please stand. Thank you, Judge.
So not surprisingly, the two people that did the most work didn't get thanked. So I guess I can begin my remarks by telling you first to the board of the Center for Justice and for the partners at Partridge, Snow and Hahn, thank you for lending us Josh and Jen, because without them, truly, this would not have taken place. It certainly would not rise to the level of one of the most awesome, wonderful, pointed conferences that I've ever had the privilege to attend. George Floyd's murder was a moment in time when our society's institutions, mostly our white institutions, took notice and declared their outrage at racism and its effects in society. But we know racism in the United States didn't begin with George Floyd. We know it dates back, at least for African Americans, to 1619. And most importantly, society can't forget about racism after George Floyd's death. We can't let anti-racism and social justice work become a flavor of the month. Now, what gives me a little bit of hope was, I think it was last week, the Washington State Supreme Court, in an opinion that they issued that my friend Mark Mandel sent to me, said the following, and it says everything I want to say about this court, and I can't get in trouble for saying it because the Washington Supreme Court said this. This is the quote. This court has stated unequivocally that we owe a duty to increase access to justice, reduce and eradicate racism and prejudice, and continue to develop our legal system into one that serves the ends of justice. Racism is endemic, and its harms are not confined to any place, matter, or issue. Whether explicit or implicit, purposeful or unconscious, racial bias has no place in the justice system. Our commitment to substantial justice rings hollow if we fail to recognize that racial bias often interferes with achieving justice in our courts. Racism is a part of our common historical experience and therefore a part of our culture. Our legal system is based on the premise of judicial neutrality, procedural fairness, and equal treatment. We know our system has not lived up to those promises, even as we've affirmed our commitment to them. The legal system is made up of people, lawyers, judges, jurors, staff, and others, and it shares in our human strengths and our weaknesses. All of us have the capacity to push our system closer to the ideals and promise of justice. We also can continue to perpetuate them. To turn our system squarely toward fairness requires conscious effort and honesty when we fail. Courts take a step toward achieving greater justice when people who comprise them comprehend the legacy of injustices built into our legal system actively work to prevent racism before it occurs, and recognize how our participation in these systems may reify them. Enjoy the conference.
Josh has authorized me to dismiss you. We will take a brief break while they reconfigure the spaces for our first morning panels. We'll see you in about 10 or 15 minutes.
Good morning, ladies and gentlemen. Can everyone please take a seat? We're going to get started. Good morning, ladies and gentlemen. Welcome to the Critical Race Theory panel discussion this morning. Good morning and welcome again. My name is Saikon Gbehan, and I'm an attorney specializing in immigration and personal injury law, and I'm honored to be here. I served on the Critical Race Theory Committee for the Federal District Court Conference Planning Session, so it's certainly a privilege to serve as your moderator, and we're gonna just jump right in. So this panel discussion this morning seeks to explore and delve into what critical race theory is and what it is not, and will challenge us to explore how the analytical framework described as critical race theory can be a resource to help us as we practice as attorneys and also work as judges. I'm going to start off by telling you a little bit about our amazing experts in critical race theory who we're honored to have speaking with us this morning. I'm going to start with Dean Angela Onwuachi-Willig. She is the Dean and Professor at Boston University School of Law. She's an expert in critical race theory, employment discrimination, and family law. She joined as Dean in 2018. Dean Onwuachi-Willig previously taught at the University of California, Berkeley School of Law, the University of Iowa College of Law, and the University of California, Davis School of Law. Dean Onwuachi-Willig is a co-editor of the book Critical Race Judgments, Rewritten U.S. Court Opinions on Race and Law, and she also is the author of the book According to Our Hearts, Rhinelander versus Rhinelander and the Law of Multiracial Family. Her articles have appeared in numerous law journals such as the Yale Law Journal, Virginia Law Review, Northwestern University Law Review, California Law Review, Michigan Law Review, Georgetown Law Journal, Texas Law Review, and UCLA Law Review, amongst others. She's the recipient of numerous awards, including the Extraordinary Woman in Boston Award in 2019, the Association of American Law Schools Clyde Ferguson Award in 2015, the AALS Derek Bell Award in 2006, and Law and Society's John Hope Franklin Jr. Prize in 2018. Most recently, she was one of the 5 Black women deans to receive the inaugural AALS Impact Award in recognition of her work in collating the Law Dean's Anti-Racist Clearinghouse Project in 2021. Let's give a round of applause for Dean Onwuachi-Willig. Next, we have the privilege of having Professor Devon Carbado. He's the professor of law at the University of California, Los Angeles. He is also the former inaugural Associate Vice Chancellor of Bruin-X, which is a multidisciplinary research unit in the UCLA Office of Equity, Diversion, and Inclusion. He teaches constitutional criminal procedure, constitutional law, critical race theory, and criminal adjudication. He has won numerous awards, including being elected Professor of the Year by UCLA School of Law classes of 2000 and 2006, and he received the law school's Rudder Award for Excellence in Teaching in 2003, and the university's Distinguished Teaching Award, the EB Award for the Art of Teaching in 2007. In 2018, he was named an inaugural recipient of the Atlantic Philanthropies Fellowship for Racial Equity. Professor Carbado writes in the areas of employment discrimination, criminal procedure, implicit bias, constitutional law, and critical race theory. His work appears in numerous law reviews, including at UCLA, Berkeley, Harvard, Michigan, Cornell, and Yale, among other venues. He is the co-author of Acting White, Rethinking Race in Post-Racial America, and author of Unreasonable, Black Lives, Police Power, and Fourth Amendment. Professor Carbado graduated from Harvard Law School in 1994, and he was the editor-in-chief of the Harvard Black Letter Law Journal. He joined the UCLA School of Law faculty in 1997, where he also served as Vice Dean for Faculty and Research at the School of Law from 2006 until 2007, and again in 2009 until 2010. Let's give a round of applause for Professor Carbado. Also, we have with us Professor Osamudia James. She's a professor of law at University of North Carolina School of Law, where her writing and teaching interests include election law, race and the law, administrative law, and torts. Professor James joined the University of North Carolina School of Law faculty in 2021. She's an expert in the areas of race, education, civil rights, and discrimination, and she's been invited to speak on these topics at numerous conferences and forums throughout the country. She is the author of numerous articles, book chapters, and popular press commentary exploring the interaction of law and identity in the context of public education. Her work has appeared in the NYU Law Review, the Michigan Law Review, and the Minnesota Law Review, amongst others. Her work has also appeared in the pages of publications such as the New York Times, Washington Post, Chicago Tribune, and Miss Magazine. She graduated from honors from Georgetown University School of Law and also earned an LLM from the University of Wisconsin. She worked, prior to joining Carolina Law, she worked for 13 years at University of Miami, and her courses included a hashtag Black Lives Matter University course. In addition to her teaching, she served in numerous leadership positions, including the Associate Provost for Diversity, Equity, and Inclusion, as well as Associate Dean for Diversity, Equity, and Community. Please give a round of applause for Professor James. So without further ado, we're going to get started. We're going to get started by having Professor speak about what is critical race theory. She's going to let us know about the basic tenets of critical race theory. Thank you.
Thank you so much, Saikon. I want to say thank you very much for inviting us to be a part of this panel. It's a real honor to be here, and I want to say it's a really courageous move, and it's really really important move, I think, to have a panel, an entire panel on critical race theory at this conference. In fact, when I got the invitation, I thought I must be being punked that the federal district court was having a panel on critical race theory, so it's really amazing. So, we thought we'd start this morning just by getting you to talk to each other a little bit, just for 5 minutes. Speak to the person next to you. Tell us, do you know what critical race theory is? Do you know what critical race theory is? And how would you define it based on what you've heard or what you've read? What are some of the things that you've heard about critical race theory just on the news? Take 5 minutes and have a discussion with each other, and then we'll take a couple minutes to hear what you shared with each other, and I'll get right into my presentation. So someone share with us first, what were some of the things that you'd heard about critical race theory?
Anyone brave? We won't attribute it to you. Yes.
Okay, great. So what it is, it's a acknowledgement of different parts of history that a lot of, throughout history, people have been trying to sweep under the rug. But I know it's a slow and steady process, but critical race theory is important to have because it's acknowledging some of the history that was basically swept under the rug. It's something about knowing your past, as well as that can also help dictate the future. Critical race theory is also when a bunch of people that disagree with some of the things that have been going on feel like they don't need to talk about it because they feel like it's something that would bring shame upon the majority group, but it's actually just an acknowledgement to know, like, something like for Jackie Robinson, who was a Major League Baseball player that has successfully passed the color line. So he was part of the Negro League, and then he made his way to the Major League. People know him as that, but they don't know what he's been through, how difficult it was for him to go through these things, as well as something like the Tulsa race riot, where growing up in a public school, I did not know anything about that until 2020 when there was like a 100-year anniversary. So these are the things that necessarily need to be brought up in public schools, because if you do not know these things, sometimes it's very difficult for you to understand other groups of people's plight, because the past always, or more often than not, helps shape the future. And it also creates a way for people that are marginalized to let their voice be heard, and also let their voices also be written down in history.
Okay, great. Are you a student? You said you were a student?
Yes.
Awesome. What year are you?
1L.
Awesome. And what's your name?
Keisha Dormina.
All right, Keisha Dormina. Everybody has to hire her. Great. All right. So a lot of things in there. Part of a partisan debate. That part of critical race theory acknowledges history. And that one of the things that people have talked about is that it might make certain people feel bad. But well, keep all these things in mind as I'm going through my presentation. Anything else anybody wants to talk about? Things they've heard of, or how they've defined critical race theory? One more? Yes. A BU student?
Yes. So as part of our conversation, we say, a lot of people hear critical race theory and they hear race and they get scared, and they don't want to talk about it because they think race is scary and they think it's something that is very combative and something that's like, okay, well, it's very volatile, we shouldn't be putting this in schools. It's not that at all. Critical race theory is an understanding, well, I'll use buzzwords from class. Race is a social construct. And understanding that the interpersonal relationships, as well as the institutionalized racism in society, how that infringes on somebody's daily experience, and understanding how to move forward with that, using the past to move to the future.
Right. Thank you very much for that. So talking about race as a social construction, but also talking about structural racism, institutionalized racism as well. Thank you. So thank you. Glad that students were speaking today. So I want to start by giving you a visual frame of critical race theory provided by my very brilliant colleague, Devon Carbado, that will provide an understanding of what critical race theory centers on, what the focus of critical race theory is. And then I'll step back and I'll take you through a detailed understanding of critical race theory and some of its tenets. All right, so first, I want you to take a look at these cows. And I want you to assume that the cows are sick. And the question is, why are they sick? So there are many approaches that we could take to explain why the cows are sick. One approach would be to blame the cows themselves. Maybe the cows are sick because they're not eating enough, or maybe they're not drinking enough. Perhaps they failed to pull themselves up even by their proverbial bootstraps. Or maybe the cows are sick because that's just how cows are. They're not as smart or as hardworking as other animals. And people might say, we try to feed the cows, but the cows simply are choosing not to eat enough. They're not taking advantage of the food that is before them. The bottom line is that the cows are sick and it's all the cow's fault. The other approach we could take is that we could take the approach of blaming the farmer for the cow's sickness. And under this approach, the farmer is the individual bad actor who is causing the cows to be sick. The farmer is mistreating the cows in some way because, let's say he prefers his chickens or his dogs over his cows, and he's not feeding the cows enough. He's not providing them with enough to drink. And the bottom line here is the farmer is the bad actor acting on bad intent, and he is purposefully harming the cows. And the bottom line is that the farmer is the one to blame. But, using Devon's brilliant analogy, if you pull back the frame, what you can see is that the cows have been living and existing in a toxic environment. And therefore, if they're going to be sick, regardless of what any individual farmer does, regardless of what the cows themselves do, for the cow, they're going to continue to be sick. For the cows to be better, the structure around them, the very environment around them has to change. It has to be made clean. And even then, there will be work to do with all the damage that has already been done to the cows. Even if the environment is clean, the cows will need to be healed before they can operate and function normally. And that's the structural frame. Critical race theorists center on the structural frame, the structure that produces and reproduces inequality and disparities regardless of what those most affected do. The bottom line is that critical race theory is a lens for examining and understanding the world, and in particular, understanding the operation and the harms of racism in our society. Just like law and economics functions as a lens through which we examine the efficiencies and the costs and the benefits of different legal rules, critical race theory is a lens for understanding the relationship between race, racism, power, and the law. And studying critical race theory involves thinking critically about forms of racial subordination in our nation's history, particularly as they relate to the development and application of the law, analyzing how legal institutions create and maintain racial hierarchies and disparities, and comparing related legal and social subordination along other axes of identity, like gender and sexual identity and gender identity. And so how do we define racism? There are lots of definitions of racism, and I'll go over a few. Right, so critical race theory examines the relationship and the interaction of racism in all of its forms with the law. So for example, critical race theory examines Jim Crow racism, which is an overtly racist ideology that contends that the social and economic standing of people of color is the result of their biological, intellectual, and moral inferiority. That's a definition offered by Eduardo Bonilla Silva, who's a very well-known sociologist. And Jim Crow racism is the kind of racism that most people are familiar with. It's the kind of racism most people think of when you say the word racism. It's explicit. It's rooted in the idea of bad intent and bad actions, right? And to return to our opening example, Jim Crow racism involves the kind of actions the farmer was taking in the approach under which we blame the farmer. We all know and understand the harms from the actions of individual bad actors under a Jim Crow system. But we also have to understand that what enabled those actions was the very structure of Jim Crow. And critical race theory teaches us that racism is far more complicated than Jim Crow racism. Racism is persistent and pervasive even without bad actors. So another kind of racism is called colorblind and common sense racism. And that's a racial ideology where individuals rationalize racial disparities and inequities as being the result of market dynamics, naturally occurring phenomena, and the imputed cultural limitations of particular racial groups. But common sense, colorblind racism is really defined by Eduardo Bonilla Silva. Ian Haney Lopez has defined common sense racism. And to use an example from sort of feminist legal theory or feminist theory, to use a gender example, one example of common sense racism or kind of an ism or common sense ism is saying something like women are underrepresented in coding because women simply don't like coding. Women aren't attracted to work like men are, and that's all said without the acknowledgement of the various factors that may be turning women away from coding. So you heard some common sense racism explanations in our cow scenario. So for example, we try to feed the cows, but they simply choose to not eat enough, and they weren't taking advantage of the resources before them. And the final thing is structural racism, which is really what critical race theorists focus on. Contrary to what some have said, critical race theory does not contend that a person is inherently racist or oppressive because of their racial background. Again, critical race theory is not generally focused on individual bad actors and recognizes that explicit racism is learned. But even more important, critical race theory is an analytical frame that stresses that racism goes beyond individual explicit prejudice and implicit bias. As Professor Tanya Hernandez has explained, critical race theory recognizes that racism is systemically embedded in laws, policies, and institutions that uphold and reproduce racial inequalities. Structural racism is a social structure in which adopted and enacted policies, practices, and cultures and other norms both produce and reinforce racial inequalities. So it's literally racial bias that's built into our systems, across our institutions, into our society. It refers to a system of policies and practices and norms that systemically privilege white people and that routinely disadvantage people of color. So this is our toxic environment. Critical race theory studies the toxic environment, focusing on the structures that enable the persistence of racism and its harms, and exploring the means for undoing those very structures. So you may be wondering how critical race theory is simply different from teaching students about our racial history. Well, in a history class or a race and the law class, a professor might cover Japanese internment, for example, as a fact of history, a fact of our history. A critical race theory analytical frame would view Japanese internment not just as a historical fact, but as a part of a pattern of racial power that continues today. Professor Tanya Hernandez provides a great example of critical race theory's different framing in her explanation of how a critical race theorist would approach teaching the Tulsa, Oklahoma 1921 race massacre from a century ago. So, as Professor Kimberly Crenshaw noted, the 1921 massacre in Tulsa is an example of how the convergence of law, institutions, and individuals enabled diabolical attacks on U.S. Black citizens. And as Professor Hernandez explained, examining the Tulsa massacre through a critical race theory lens would involve unearthing the conditions that allowed white institutions and white leaders of the time to mobilize the law to set a massacre of hundreds in motion and then uncover the long-term consequences of that massacre. So the legal dimensions of that massacre involved formally deputizing and arming of white citizens, the rounding up and interning of survivors, and the filing of charges against victims for inciting violence. The massacre's legal aftermath was a failure to indict or prosecute anyone. The massacre's legal backdrop were segregation laws that corralled blacks into certain neighborhoods, and segregation laws that shored up the economic segregation of professions that then fostered white resentment of what was called Black Wall Street and contributed to the racial disparities and wealth accumulation that exists today. So that's the kind of thing that a critical race theorist would also be exploring. So what are the basic tenets of critical race theory? Well, the first one is that race Oh, yeah, wait. That race is socially constructed. So one core tenet is that race is not biological, that rather race is a social construction. So according to sociologists Michael Omi and Howard Wynett, race is created, it's inhabited, it's shaped, it's transformed by social, historical, political forces. And all of that in turn creates meanings that are then attached to different racialized groups. And these social meanings have material consequences in terms of how people are treated and how goods have been and are distributed. So if race were not socially constructed, right, one of the things that how do we know race is a social construction? If race were not socially constructed, then race would be constant across all regions. And if you look at different countries, we have different people are defined differently according to race. So for example, somebody who would be considered black in the United States, according to the one-drop rule, right, might be considered part of a different racial group, a racial group that does not even exist in the United States and South Africa, right? So in South Africa, there's this whole other racial group called the colored racial group, right? That person would be black in the United States, that person would be colored in South Africa, right? So if it was really constant, if it was really a biological thing, you would find consistency across all places. Some people may say, well, if race is socially constructed, well, why isn't it enough to say that we will just simply ignore race and then everything will be equal? Well, what's important about race and racism are the social meanings that get attached to different groups. And just because race is socially constructed doesn't mean that that construction doesn't come with real consequences. And the best example is money. So consider the dollar bill. It has no inherent meaning other than the meaning that we have given it. It is a social construction too. But that doesn't mean that I could pick up a blank piece of paper, write $1 on it, and go to a store and try to spend that $1. It comes with real consequences there, right? Same thing also happens with race. Give you a couple examples about the social construction of race. Osagie Obasagi did a great study where he looks at the social, that I think really debunks this idea both of colorblindness and helps to show how race is socially constructed. He wrote a great book called Blinded by Sight, Seeing Race in the Eyes of the Blind, and involved interviews of more than 100 individuals who were blind from birth. And he found that even though blind people could not, quote unquote, see what we think of as race, visual race, he found that race very much mattered to blind people. And so both debunked the myth of colorblindness in law as the ideal, the notion that for law to be fair, it must be colorblind. And it showed that racial formation is a social process. So even those who could not perceive visual race learned about the social meanings attached to different racial groups and treated people differently based upon those social meanings. I'll show you a couple of examples from his study. And these are both that involved dating. So he's speaking of a quote from one of the subjects who said, speaking of a friend who was blind and white, he was going to college and had started working with a reader. She was very attractive to him, and he started seeing her. Then somebody told him that she was black, and he broke it off. He broke off the relationship. He justified it by saying that it would not have worked in the South for a white man to be involved with a black woman. Then another one, speaking about his experiences of a blind black man when meeting other blind people in his dating life. A lot of my black blind friends have sort of a joke because when someone doesn't know our race, especially the males, they find some way to reach out and touch our hair. People always come up with some kind of way to touch our heads. They'll massage you or do something, and I think this happens mostly in dating. You know, if they're going to make some decisions, I've seen people that seem sort of interested in someone and then discover that they're black and change their intentions. I go to a lot of conventions now, the national conventions for the blind, and there are people trying to meet somebody to date. You can see that they're kind of pursuing somebody that they find attractive, and they'll go for the hair, and then they'll change their mind. They're always still friendly, but you're black. And other examples. So for example, the social meaning of blackness as criminal and violent has resulted in the following different disparities in policing, right? A psychological study involving some subjects. Researchers found that participants typically shot black targets armed and unarmed more frequently than white targets. That even when participants responded correctly, they typically shot an armed black target more quickly than an armed white target. And that in response to an unarmed target, participants indicated don't shoot more quickly when the target was white. Here's another study by Jennifer Eberhard, who was a MacArthur Fellow. Subjects were primed, were primed with a picture of a white male, a black male face, or an abstract shape for 30 milliseconds, too short of a time for the participants to consciously realize what they had seen. They then watched a short clip of a picture over the course of 41 different picture frames. And the clip began with an unidentifiable blur. It became clearer with each frame and ultimately revealed a gun. And subjects primed with a black face identified the gun much more quickly than those with the other two groups. So I'm not showing you, you can see it much more clearly here, but it starts off much more blurred. But by the time they get to that frame, and they are identifying it much more clearly at a much earlier stage with the black face than with the white face. Another tenet is that people see themselves differently and are seen differently based on identity characteristics. People of color, and that people of color bring unique perspectives due to their experiences with race. So we experience life in different ways, in part because of our race, and that means we look at the same events and we understand them differently. So take, for example, policing. If you look at any Pew Research poll on policing, you see how race shapes individuals' views on policing and on police precisely because of their lived racialized experience, whether racialized as black or racialized as white. And we know that our experiences based on the police's perceptions of our race shape how we each view and understand a video, how we might each view a case, an interaction, or anything involving the police, how we view our freedom to move in our own car when stopped, how it shapes whether we might think we might survive a particular encounter, how it shapes whether we think we might be able to walk away from our encounter when we technically have the right to walk away from that encounter, how it shapes what talks we have with our own children about what to do when they're stopped by the police. Critical race theory acknowledges that the realities of people of color are often excluded from the law and asserts that they should be included and recognized because of people of color's unique voices. And I'll show you just a couple of examples of some disparities in terms of how people, this is just a poll by the Pew Center taken just before the murder of George Floyd. And you see wide racial differences in terms of the confidence people had in police officers acting in the best interests of the public. Also, here's another poll. How does the criminal justice system treat people who injure or kill civilians, right? Another tenet is that racism is not aberrational. It's just nothing. It's not extraordinary. That it's really part of the ordinary. It's business as usual in this country. And the racial disparities that we see in our country are the result of decades of racialized laws, policies, and practices that continue to influence and that shape the lives of people according to race. Moving. Racial subordination serves both psychic and material purposes in our country. And racial subordination is about more than just the disparities in wages, access to jobs, access to health care, and other material benefits. It's also about what W.E.B. Du Bois called the psychological wages of whiteness, the meager compensation that some receive just in knowing that they're not at the bottom of the social hierarchy, and knowing that others, for example, African Americans, are at the bottom of the social hierarchy. And so I always like to refer to a joke that Chris Rock once made when he's talking about the social hierarchy, because I think it really illustrates it quite well. And he's talking about people who quip that, the comments like, oh, I wish I were black. And he says he made a quote, said, there ain't a white man in this room that would change places with me. None of you would change places with me, and I'm rich. The other thing is, critical race theory says it really critiques and challenges colorblindness. A colorblind approach cannot actually advance substantive equality. Colorblindness won't end racism. Instead, it actually reifies racism. Current legal doctrine assumes that colorblindness is the most effective means for combating and eliminating racial discrimination and subordination and its effects. As we see with things like affirmative action, efforts on the part of public schools and colleges and universities to racially integrate or diversify are subject to the same kind of judicial scrutiny and skepticism as efforts on the part of those same institutions were to racially segregate students. From the court's perspective, and from our court's perspective, because both integration initiatives and segregation initiatives necessarily rely on race, both should be treated as suspect and therefore should be subject to the most heightened scrutiny. Critical race theory critiques this approach, what Professor Ian Haney-Lopez calls the court's intentional blindness with respect to ongoing realities of race, by highlighting how race remains a salient feature in our society. To put it simply, race really matters. And critical race theorists ask questions, as Devon and I did in our recent edited volume, Critical Race Judgments. How can one meaningfully address racial inequality without explicitly asking about and invoking race, right? Without directly targeting racial inequality. So imagine, for example, trying to diagnose and medically treat cancer by taking a cancer-blind approach, right? How would one begin to eradicate cancer with taking a cancer-blind approach? Would anyone seriously support a rule that prohibited doctors or researchers from ever talking about, even talking about cancer or directly targeting cancer for eradication? Different racial groups are racialized. Another tendency, different racial groups are racialized in different ways. The discrimination and bias that African Americans may face may differ from the discrimination and bias that Asian Americans may face, for example. So, for example, African Americans tend not to be viewed as perpetual foreigners in the United States. I'm actually, for example, from an immigrant family. Was born here, but I'm the daughter of immigrants. And yet no one ever asked me, in the same way that they might ask my Asian American friends, where are you from? When they say California or Texas or wherever. No, where are you really from? People simply assume that I'm American. There are different forms of racism, not to say that one is worse than the other, but the different groups experience racism differently, and yet there's a tendency to try to assume that the racism all must be the same. No person has a single, easily stated, unitary identity, and every person experiences the world based on interlocking identities. A lot of people with intersectionality, anti-essentialism, that the way that we experience the world might depend upon our various different interlocking identities. A black woman does not necessarily experience the world in the same way that a black man does, right? And so on. You could add many, many, many different identities to that. And finally, I know I've gone long, storytelling and narrative are helpful means for ensuring greater inclusion of different voices, and they also help to make the law more accessible. Critical race theorists really, really believe that storytelling is a way to include underappreciated, underrepresented voices, and that it also makes the law more accessible so that those who historically and traditionally been locked out are able to be included. And it's also a great way of challenging kind of the stock stories that we have for so many things in our society. Thank you.
Thank you very much. And now we're going to invite Professor James up to come and speak about how critical race theory is used or taught in schools.
Absolutely.
Thank you. Good morning, everyone. How are you? I want to join my co-panelists in thanking conference organizers, especially Jennifer Wood, for reaching out and putting this together, and also share their enthusiasm for having these sort of conversations in spaces like this. It's really exciting and encouraging. Okay, I have been asked to talk a little bit about how critical race theory is taught in schools. And while we find the slides, I do want to, there's a sense, some of the controversy around CRT is that there is this ideology that's being pushed on students, right, in the first year. They don't even know what's happening to them. It's being placed on them, right? Or that there's a way in which people are being indoctrinated into a particular way of thinking. And so what I'm trying to do today is help you understand how do we talk about critical race theory in law schools? What are the ways in which the lessons of critical race theory are used in law schools? And what are the ways in which it's not being used? I also want to make clear that the controversy around CRT that's happening now in political spaces is not the same as CRT as a graduate level methodological inquiry about race, right? That is a political movement, right? And really using the label CRT to push back against discussions of race at K-12 education. There's always been discussion or conversation about race in K-12 education. Some schools do it more explicitly than others, and that's more properly called anti-racism education. After George Floyd's death, it became much more visible. A lot of educators thought, well, gosh, maybe I need to talk about this more explicitly, and there was a movement to try to do more of it. It became very visible, and then it also became useful as a political tool for galvanizing voters. If you can make parents feel like something bad is happening in their schools, they might show up and vote in particular ways. And that's very different from thinking about CRT as a legal theory, like law and economics, like critical feminist legal theory, like queer theory, which is a lens for thinking about a particular phenomenon in American legal institutions. So having clarified that, I think there are two ways we could think about studying or teaching critical race theory. And one is just as a legal theory, right? It's akin to any theory for taking a look at phenomenon. And so my co-panelist has already gone over some of the key aspects of critical race theory, but I want to establish that critical race theory is a systemic, race-based critique of legal doctrinal development, legal reasoning, and legal institutions. And in that way, it's really different from criminal law, different from immigration law, different from poverty law, different from welfare law. All of those areas implicate race, absolutely, but that's different from a comprehensive, thorough way of thinking about how is race operating in the legal system. There are some key methodological commitments to critical race theory, and so if you enrolled in a class, you're going to take your CRT class, right? I teach a law and race class, which is actually not the same, but if you take your CRT class in law school, you might think about the commitments of scholars who do critical race theory, and I want to focus in particular on one methodological commitment, which Angela just mentioned, which is the idea of legal storytelling or narrative analysis. We might also call it standpoint epistemology, right? The idea that people's experiences with race and law is a useful source of knowledge, right? It's a useful source of expertise that we might use to better understand how race is operating in the law. There's sometimes a thought that, well, if you tell a story, that's subjective, right? That's your personal experience. That's not objective. How do we rely on that? But in fact, it's a way of trying to open a window into alternate realities, right? I experience it one way, you experience it a different way. Can we think about how how law is cultivating that? And also to consider ignored realities, right? We look at a story about let's think about sort of Japanese internment, right? One story is that these were people who were disloyal, and the law told us that story. But the other story is about citizens, right, who were disenfranchised, right, and labeled as a result of phenotype in the middle of wartime activity in the United States. And so, and the idea that we don't have to tell stories, because that would not be objective, that would not be legal, that would not be scientific. In fact, the law tells us stories all the time. And so going back to my example of Japanese internment, that story that the law was telling us was that Japanese people were untrustworthy, right? That's a law that gets put out into, a story that gets put out into society, and we might use critical race theory and use a commitment to narrative storytelling to give a counter story about what was happening there. Stories like Black people are untrustworthy, right? Mexicans are illegal aliens, Those are stories that legal structures give us, and we take, even if we're not legal actors, we take those stories with us, and it shapes the way we move through our life. And so CRT really acknowledges the power of counter storytelling, opening up windows into alternate realities or ignored experiences in ways that help us better understand how the law is working, right? Can we rely on stories to understand the entire system? No, but can we rely on stories to help us better understand what's happening and where we might need to intervene and the work that the law is doing even when we don't intend it to? Absolutely. We might think about the canonical texts. I was just telling Saikon that in law school, I took a class with Charles Lawrence. Marie Matsuda was my torts professor, and I had no idea that these were two of the founders of a movement that we now understand, that we call critical race theory. And so if you take a CRT class, then you might learn about some of the sort of the canonical texts and the founding authors and scholars in this area. So Derek Bell's Serving Two Masters. This is a work about the tension between integration ideals and client interests, right? What clients needed during lawyers' movements to try to achieve desegregation and integration, and what was going to be palatable to other interests that were supporting that work. You might read about Brown v. Board and the interest convergence theory, giving us an alternate story for why Brown happens. We have a story that Brown happened at the right moment. It was the right thing to do. The justices saw that. It was unconstitutional to keep schools segregated. But this foundational work says, no, there were other interests at play, and we'll talk about this a little bit more in a couple of minutes, that compelled judges at that point to make that decision. It didn't look good for the United States abroad fighting communism to continue to segregate at home. It wasn't good for veterans who had fought abroad, Black veterans, to come back to the United States and decide that the equality that they had experienced in the military was not going to be made available to them here, right? And so maybe the judges got together and thought, this is the moment to make a different decision for political reasons, for economic security, for national security reasons. And that's a different story about why that happens. But thinking about a different story might allow us to think differently about political strategizing in the future. So I'll come back to that. Race reform and retrenchment, the idea that even as we develop anti-discrimination law, it actually helps us often re-entrench racial inequality and trying to understand how that's happening. Whiteness as property, the idea that access to whiteness is like a bundle of sticks that you own. You can use those tools. You can exclude people from getting access to whiteness. The courts can reaffirm your interest in whiteness. And if we think about that as property, a property right, an intangible property right, are there insights that we get about how race operates and how law helps to re-entrench the salience of race? The ego and equal protection, this is a work that radically changed my understanding of equal protection as a law student. The idea that yes, unconscious racism operates when we think about laws and their impacts on people. And so coming up with a way of having legal actors and judges account for unconscious bias, which is not always obvious. How can we assess whether unconscious bias is impacting the way judges are making decisions, impacting the way laws are being applied, and can we account for that in different ways? What sort of tools might you come up with? And I remember thinking, up until that moment, it still hadn't clicked for me why we had these equality laws, but we weren't yet all equal, right? And that article really opened up a window for me in terms of thinking about what is actually happening here. There are various forms in which race and law are interacting to disadvantage people. How do we name them? How do we engage them in legal systems? How might judges account for them? And then you might also talk about founding scholars. This is Derek Bell, Marie Matsuda, Angela Harris, Charles Lawrence, Neil Gatanda, Kimberly Crenshaw, Rachel Delgado, Alan Freeman, Kevin Johnson, Margaret Montoya, and there's so many others. And so I list them not to suggest, well, I know who the people are and you don't, right? But rather to really drive home that there's a group of committed scholars in the past and ongoing who are building a body of knowledge here, the way you would build a body of knowledge in any other field, right? And they can be turned to for expertise. Sometimes they're pushing the boundaries. Sometimes they want to go beyond the black-white binary, apply it to different groups, see it in contemporary forms. And that often with race, we tend to think, I don't think about it, and so there's nothing there to study, right? Or I have a race, and so I must be an expert on it. Yeah, right. The other topic I teach is education law, and everyone's like, well, I've been through school, so I'm an expert in education, right? Wrong, right? And so in both of those areas, these are disciplines. There's a vocabulary, there's a methodological lens, there's a group of scholars who are doing work, there's opportunities to try to control for information, to gather empirical data, to think about it in terms of application of theory, and that we have to take that study seriously, right? It's not just people's thoughts about race that are equal to everyone else's thoughts about race. These are experts who have something particular to tell us if we're willing to consider and to listen. But my sense is that that is actually not what's driving any interest about the study of race in law schools. But sure, no one has a problem with the law student who decides voluntarily to sign up for their CRT course. And really, I think what drives interest is the idea that students are unwittingly being exposed to this in their other courses. And so I want to talk a little bit about, I had a point here about CRT, critical race theory, being like feminist legal theory, being like law and economics, being like queer theory that come up across the curriculum. You can study them if you like. But I think the idea is that CRT is being deployed throughout other parts of the curriculum. And so I want to take some of the tenets of CRT, some of which my co-panelists has already mentioned, and then talk about what are the insights we get from that tenet and where might it come up in the law school curriculum. And so one tenet is that race is a product of law, ideology, and social relations, and not the other way around. We tend to believe that there's racist sentiment, and then we adopt laws to propel that racist sentiment. But in fact, we adopt laws that help us create the idea of race. We adopt laws that help us create the idea of racial categories. We adopt laws that help us create racial hierarchies. And so I guess I'm going to look for a little participation, although I'm happy to cold call if necessary. What are ways in which laws have created race in the United States? Actually, I am going to look. Oh, no. Is that okay? No. Sorry. Okay, thank you. Okay, so what are ways in which laws create race in the United States? I'm looking for a volunteer. You're going to let the students show you up, right? The whole panel? The whole panel? Okay.
Testing. Okay. Well, in con law, we can think about how at the beginning of when this country was created, who was granted citizenship and who wasn't.
Good.
And that, Black people were not. And
Okay.
so we were not thought of as human beings.
Good, right? And so the idea that we have law that creates these categories. Some people are in, some people are out, some people can own, some people can be owned, right? And that creates categories. Any other examples? Yes.
Immigration law. Immigration law divides people based on race. So if you're from Cuba, for example, come on in. If you're from other countries where the U.S. might have done damage, like Afghanistan, then, you're going to be given privileges versus someone who might be here from Central America.
Good. And so immigration law will certainly create categories about who can enter, who cannot enter, who is a citizen, who is a non-citizen. But it also ascribes racial meaning to those inclusions and exclusions, right? And sometimes we think about our racial categories, and we can think about how Mexican people have been racialized as a separate group, and that it overlaps with our perception of them as non-citizens, right, or as interlopers or foreigners entering the United States. Good. Any other? I'll take one more example. Yes?
The prerequisites required for Native Americans that they're members of a tribe, and and that ignore a history of storytelling which really created the tribes in the first place.
Okay, good. Right, that's another way in which law creates racial categories. I also thought you were going to mention the racial prerequisite cases, a series of Supreme Court cases in which the justices were trying to decide who was white and who was not white. And they were employing various methods. Well, common understanding. Everyone knows that we did not intend for Asian people to be white, so duh, right? That's the legal analysis there, right? But also, what did the person look like, right? Obviously, some people look white and so are white, and some people don't look white and so are not white. Where did the person come from? Well, if they were born here, right, they might be closer to white than people who are coming from someplace else. And then we get these categories and we assign benefits and privileges to them, right? And so that's a situation in which law is creating race. Race is not creating racist law, right? Law is setting up populating those categories, giving it meaning. And so you've mentioned some of what is on the slide here, law as a basis for group differentiation. So it creates categories, black, white, yellow, provides criteria for how people are going to be assigned to that category. What do you look like? What is your ancestry? Then it assigns social meaning to those categories. If you can be in this category, you are superior. If you are in this category, you are inferior. If you are in the Japanese category, you are disloyal, right? Going back to that storytelling. And then it uses those meanings to structure hierarchical arrangements, right? If you're superior, then you're top. Inferior, you're on the bottom. Disloyal, you're towards the bottom, but maybe not all the way on the bottom. And then it confirms the social meanings that it helped to create, right? Why are people enslaved? Because they're inferior. The law wouldn't allow that unless they deserve that status. So what courses might some of these takeaways come up in? Go ahead.
Well, property, for one.
Property.
I mean, that's the foundational one.
Absolutely. What else? Now you have the mic, so. Any other courses? Where else might these ideas, go ahead.
Employment opportunities.
Employment law. Where else? Criminal law, right? Immigration, administrative law. All right, when we talk about agencies, right, we had a federal agency that helps sort of establish and find runaway slaves, right? That's a way in which a legal structure is helping to establish racial categories. And so the idea is not that we should turn these courses into CRT inquiries, but rather when these ideas come up in these classrooms, CRT can give us a structure, a vocabulary, right, a methodology for understanding what's happening that then deepens our understanding of that substantive category. When we talk about property, how do we talk about the qualities of property, what property does, how do you access property, how do you deny people property, and then we think about this in the context of race and owning human beings as property. CRT can help us understand how those dynamics operate and how those dynamics created not just a system of slavery, but a system of hierarchy, right, that is still with us today. Another insight, race is a product of social thoughts and relations. This idea that race is socially constructed, race is not inherent, it's not objective, it's not fixed. And so in what ways does, more Q&A, in what ways does law construct a notion of race, of who's in one category and who's in another? Let's talk about criminal law. How does criminal law construct our notions of race? Go ahead.
Sorry. Hello. Criminal law creates categories like felon or not felon, and those categories are disproportionately impacted into racial groups, but it's not explicitly defined in that category.
Perfect, right? And so who is the criminal and who is not the criminal? And who we decide is the criminal is not, an objective teaching that comes down from the heavens. And these people are obviously criminals and these were not. We make choices about what behavior we're going to call criminal, right? Is smoking a particular drug going to be criminalized? If it is, okay, do we think that a disproportionate portion of society uses that drug or doesn't. In general, drug use is consistent across racial groups, right? But if we, in our heads, we think we're going to criminalize marijuana because we believe that people of color or black people are more likely to smoke marijuana. If those two things are happening at the same time, then we see a way in which criminalizing marijuana use will then tell us that people of color are more likely to be criminals. If the Supreme Court tells us that running away from police officers is grounds for reasonable suspicion, right? Well, who might be more likely to be running away from police officers? Who? Black people. Black people might be more likely to run away from police officers, not because they're doing things wrong more often, but because there's a history there of troubling interactions, right? You might be raised in a community where you don't trust the police, where you have stories of police planting evidence, lying, police brutality happens in your neighborhood, right? You might be like me, I have a son, and I have to talk to him about interactions with the police, and I have to teach him that police might look at you as more dangerous even though you're 10, right? Even though you're where you're supposed to be. And so you have to have a different engagement with the police. And so he might think, I should run when the police show up. Right? And so if we know that communities of color or communities that have had difficult relationships with police are more likely to run, and then we say people who run are suspicious, then we see a way in which a legal doctrine is helping us decide who is and isn't the criminal. Tax law, who is the taxpayer, who is the tax cheat? And here I'm actually thinking about the way in which we've been criminalizing parents who address falsification. Parents who use a different address to try to get their child into a better school system. And the idea here is that if you're lying and you don't belong to the school system, you're cheating the rest of us out of our taxes. But who might be more likely to be trying to get their child into a different school district because the neighborhoods in their communities are not properly serving their children? People of color are more likely to have this issue. It's not across the board, right? In fact, like white people also struggle with school systems, and white poverty is a real phenomenon, right? But we think that people of color might be more likely to be engaged in this sort of behavior, and we criminalize it. So one, contributing to who we think of as the criminal, but two, who is the taxpayer, who is the tax cheat, and these legal rules, these legal conventions, these decisions to prosecute, they all contribute to a larger sense of who is in which category, and it becomes racialized. Tort law, who is the reasonable person? I want you to close your eyes for a second. No one's looking but me. I'm definitely laughing, but that's okay. Close your eyes, okay? And I want you to imagine the reasonable person. What is that person's gender? What is that person's age? What is that person's physical structure, size, or ability? What is that person's race? I'm just going to wait a little longer so I can look at you with your eyes closed, because it's funny from this standpoint. Okay, open your eyes. And I won't ask for volunteers, but sometimes I do this exercise with my students, and they, after a while, admit, I thought of someone who was white. Some people say, no, I thought of someone who looked like me, right? I thought of someone who was physically able-bodied. I thought of a man. I thought, right? And so I do this exercise to show them that we have ideas in our head that map onto these legal principles that we teach. And they reflect our ideas about gender, they reflect our ideas about ability, they reflect our ideas about race. And keeping that in mind helps us when a moment comes and you had a reasonable person in your head and the person before you is not that person. They look different, or they look like how you might have imagined them to look, but they behave differently than you thought they should behave, right? And all this is linked to the idea that race and other identities are socially constructed. We tell stories about them, we receive images about them, then we go back out into our practice and we expect to see those stories play out, that we can do work to change those stories, to broaden those stories, but that all of this is constructed. None of it's fixed, none of it's objective, right? And race is a product of social thought and relation, that's a tenet of CRT, and understanding that principle that comes from that body of work can help us discuss this in our classrooms in ways that are generative and useful for practice. CRT repudiates the view that status quo arrangements are the natural result of individual merit and agency. It argues that we have historically accumulated social effects of race, that they can be inherited, that there are economies of racial hierarchy, so we have racial shelters, there are hidden and protected racial privileges that we can pass on, there are racial taxes, hidden and unprotected racial costs that we don't always acknowledge, and that colorblindness doesn't necessarily get us race neutrality, color consciousness does not necessarily produce racial preferences. And so, some of the areas in which these ideas might come up include anti-discrimination law, equal protection, constitutional law. Again, the point is not to turn these areas into an entire semester-long inquiry into CRT, but rather that CRT gives us language and ideas to help us interrogate these areas. Why is constitutional law working the way it is? Right? Does it do the work that we'd like it to do? Well, we can talk about colorblindness. How does that operate? What impacts does it give us? We can talk about the economies of racial hierarchy. Are there shelters that con law is protecting? Right? Are there taxes that con law is imposing? Is that why it doesn't work the way we might want it to? I want to talk a little bit about the interest convergence theory. This is the idea that the interests of blacks in achieving racial equality are only going to be accommodated when it converges with the ideas of whites. This is the insight of Derek Bell. So that the 14th Amendment by itself is not going to authorize a judicial remedy if that remedy is going to threaten the superior status of middle and upper class whites. And so using that insight, Bell then applied this to the Brown decision. It cannot be considered without understanding the value of that decision to whites, not only in terms of morality, but in terms of economic and political advances that were needed in the United States at the time. And when Derek Bell sort of leveled this theory, it was pretty, I'd say sort of earth-shattering. People were like, what? Brown was not this wonderful moment in American legal history where we moved forward together, right? And things have been better since then. And he just said, no, there were other motives at play. And a lot of people pushed back on that. But then legal historians confirm part of the story. So Mary Dudziak has done some of this work and found materials among the justice's own archives, but also other political information that helps give credibility to the story that the United States needed a win in terms of race at home so that it could also win abroad. Is that the only reason for the Brown decision? No, there are many factors at play. But if we understand that sometimes these moments of racial progress overlap with benefits to superior groups, or groups who are higher on the racial hierarchy, I don't mean superior normatively, then it might change how we analyze the decision. We might predict the instability of a decision like Brown. Right? If it only happened because it benefited a particular group, when it doesn't benefit that group anymore, are we going to lose? Right? And I would argue we're seeing quite a bit of that right now. Diversity, a very unstable rationale. Why did we get diversity? Because at the time it was justified as being great for American corporations, for students in classrooms, for military. And once that rationale doesn't take us anywhere anymore, it's undercut, right? And we're seeing a pullback from diversity. And so there are other benefits that we saw here that were necessary. And we might see these insights in constitutional law, education law, again, just helping us better understand what's happening. It changes strategy. If you think you need political alignment, then you make different decisions if you understand that those are the moments in which we move forward. I think the last slide I have is about intersectionality and anti-essentialism, the idea that we have overlapping identities and that law responds to you differently as a result. And CRT really focuses on using essentialism as a tool to highlight discursive frames that disadvantage people of color. So we have these terms: colorblindness, merit, illegal alien, the war on drugs, the war on terror. citizen, right? And so to use any categories to flatten that person only to that category, and there are problems with that. But when we engage in this, sometimes what we're doing is looking at the language and understanding how does this category in the law, which does flatten, but how is it used to disadvantage some people and advantage others, right? And that helps us better interrogate what's happening with the law and how it is that law continues to create a racial hierarchy, even though the language seems neutral, right? Race is not listed in any of these terms, and yet they have racial implications with them that we want to excavate and interrogate. And I'm going to stop there and pass it on to Devon. Thank you so much for your attention.
Thank you so much, Professor James. And now we're going to invite Professor Carbado to come up and talk about how critical race theory is used in the practice of law and to discuss the application of critical race theory in litigation.
So I'm delighted to have the opportunity to engage you all in this way. At the same time, I'm in something of an impossible position following my terrific colleagues and standing in the way of you and lunch. So I'll do the best that I can. The title of the presentation is Critical Race Theory and Legal Doctrine, and I think it's fair to say that the title is as descriptive as it is unimaginative. It's not a pretty exciting title, but I'm trying to do two things in the time that I have. One, I want to continue on a theme about why it might be important for us to think about race and racism via a structural frame. So I'll build on some of the comments that you've already heard, and then two, illustrate how that particular understanding might be relevant for specific legal disputes. So I want to go back to the image with which Angela began her presentation. This is not an image that I created. It's one that I've worked with Kimberly Crenshaw in doctoring up an image from the Framework Institute to make precise to the point that Angela made, which is to say that if you're focusing on just the cows and focusing on just the farmers, then you'll miss out on the degree to which there's a threat in the air. And the question is whether or not we can think about the threat in the air in another way, whether racial disparities that exist across various domains of American life might be understood as a threat in the air as well. And there are a number of different racial disparities about which we might be concerned. This list is not intended to be exhaustive, and you can look at the list. I don't need to read out all the items, everything from healthcare to incarceration to housing to employment, etc. No one disputes that these particular disparities are features of American life, and they help, again, to focus our attention on the structural frame. So I want to build on that structural frame by having us do a little bit of math. Now, none of us went to law school to do math. I get that. But the math that I have in mind is not statistics, it's not calculus, it's not even algebra. It really is just basic addition. And this, too, is a moment in which I need your participation. So imagine that I'm the flight attendant, you're sitting in my exit row. I need you to say, yes, you will participate. All right, that's a pretty solid yes. All right, so look, here's the structural math that I'm thinking about. So we'll call it a structural racism math. Again, I've said that it's basic addition, and I really do hope that you'll quarrel with me, express skepticism if this doesn't work for you, because I'm trying to think through whether this is a useful heuristic to explain how racial inequality might accumulate. So the first item in the math that I want you to think about is racial inequality 1. So at some particular moment, there's something we will call racial inequality 1. No one disputes that racial inequality 1 happened. Everyone agrees that, yeah, that's true. Next, we introduced a civil rights intervention. Again, everyone's on board. Everyone thinks, yeah, you're right. This civil rights intervention happened as well. The math problem that I want us to think about is this. When you subtract the civil rights intervention from the racial inequality, what do you get? What's the answer? There are two possibilities. One is you get 0 racial inequality. That is to say, the civil rights intervention is enough to draw down that racial inequality to 0, or you get a remainder racial inequality. What do you get? I'm not going to ask you to answer that question yet. This is a little abstract. I'm going to particularize it. Let's say that racial inequality, one, is slavery. No one disputes that slavery was a part of the United States scene. Let's say that the civil rights intervention is Reconstruction. No one disputes that Reconstruction was a part of the United States scene. The question becomes, when you subtract Reconstruction from slavery, do you get zero racial inequality, or do you get remainder racial inequality? So after 3, I want the answer. 1, 2, 3. Okay, this is not I told you could do the math. This is not particularly controversial. I don't think that anyone can fight me on this particular point so far. Now, what's shocking about this math in relationship to history is that even in the context of Reconstruction, where civil rights legislation was being promulgated to deal precisely with this remainder, the Supreme Court treated that civil rights intervention as a racial preference. So here's what I mean. The civil rights cases were decided, again, in the late 1800s. At issue in the civil rights cases is something like the following question. Congress passes a law that says you cannot discriminate in the context of public accommodation. So restaurants, hotels, inns, etc. We're discriminating, and Congress said, stop the madness, this is Reconstruction, we're trying to rebuild another nation. The Supreme Court is called upon to determine the constitutionality of that legislative initiative, and the court says it's unconstitutional. And it uses this particular language. When a man has emerged from slavery and by the aid of a beneficent legislation has shaken off the inseparable concomitants of that state, there must be some stage in the progress of his elevation where he takes the mere mark of a mere citizen and sees it to be the special favorites of law. So the idea of special rights, of racial preferences, are not new ideas. This idea circulated in the context of Reconstruction, where we've said that the answer is B. But let's carry on. So to carry on, again, from this racial remainder inequality, we start with it. So our next problem has to bring over this racial remainder inequality, but then we've got to add to it. What are we adding? We're adding racial inequality 2. And again, no one's going to fight you on the degree to which racial inequality 2 was a part of the US scene. Not going to get much quarrels about that. Civil rights intervention 2, no one's going to fight you on that either. Let's stipulate that there's utter and complete consensus that this happened. The issue, once again, is what happens when you do that math. What happens when you subtract civil rights intervention 2 from racial inequality 2 and remainder racial inequality 1. What does that look like? And once again, I want to particularize it. So the racial inequality 2 this time is Jim Crow. You can't argue with the fact that Jim Crow was a part of the American landscape. The civil rights intervention is Brown, an enormously important part of our constitutional history, no doubt. So the question again is, what's the answer when you subtract Brown from Jim Crow plus remainder racial inequality? After 3, 1, 2, 3, what's the answer? I mean, it's pretty hard to say that that intervention draws down racial inequality to 0. Now, we could go on and on with this. I won't go on and on with it, except to say that, look, you can pile on. So racial inequality 2 plus massive resistance to Brown. Everyone understand that was massive resistance to Brown, plus massive voting rights violations, plus de facto segregation. No item that I have on this list is really contestable. Each item is verifiable US history, no matter what your ideological perspectives might be. I think it's hard to fight me on the items that I have here. And then when I minus, again, the civil rights intervention, this time the second Reconstruction, so I'm thinking about the Voting Rights Act, I'm thinking about Employment Discrimination Act, I'm thinking about housing discrimination, and we're clustering these as our civil rights intervention and calling it the second Reconstruction, we still don't get 0. We still have a remainder racial inequality. Now, in some ways, I'm riffing on a theme from Martin Luther King, that iconic figure in American political consciousness who was at the forefront of civil rights engagements. We all remember, of course, his speech on the March on Washington. We remember the line about the degree to which we should judge people by the content of their characters and not the color of their skin. We remember as well, presumably, this dream of white kids and black kids holding hands in interracial harmony. In that very same speech, King also had this to say: "We have come to this great nation to cash a check. When the architects of our republic wrote the magnificent words of the Constitution and the Declaration of Independence, they were writing a promissory note to which every American was to adhere. America has defaulted on this promissory note insofar as our citizens of color are concerned. America has given black people a bad check, a check that has come back to mark insufficient funds." Now, when we think about King, we're not necessarily thinking about this language, but this language is part of his I Have a Dream speech. So King presumably is thinking about something like this, where there is a check that's written to black people. It's from the government. It's for civil rights. But it comes back marked insufficient funds. In other words, the check has bounced, to use the more colloquial expression. Now, in my math exercise, I'm actually assuming that the check cleared. The point I'm making is that the civil rights check has never been enough to deal with the racial inequality problem it inherited. To put it another way, you always get this remainder racial inequality precisely because the civil rights check was not enough. And one of the ways to understand that is to trade on a particular doctrine in law, which is to say remedies, and ask, what has the remedies for racial injustice looked like largely in the US? Well, they've taken the form not of damages. It's not really damages that gets dished out. It's more kind of injunction. It's kind of a partial injunction. So we'll say, stop slavery, kind of. Stop Jim Crow, kind of. There's never a moment of redistribution where you're trying to really level the playing field. After slavery, you're not leveling the playing field. After Jim Crow, you're not leveling the playing field. Nothing is done to level the playing field, and it's precisely because nothing is done to level the playing field that you're always carrying over this racial inequality. And it's precisely that carrying over of racial inequality that we see in these racial disparities today. These are not free-floating racial disparities that come from nowhere. They come from the fact that racial inequality has never been erased to zero. Law has never been mobilized. Social policy has never been mobilized to clean racial inequality so that it is nothing. And so what I want to do now is think about some of the doctrinal implications of that fundamental idea. And I want to explore those doctrinal implications in two domains, and then stop. One is equal protection law, and the other is Fourth Amendment law. So with respect to equal protection law, you all know, I should test you on this, but I won't. You all know that underwriting equal protection law, and as Mudia's presentation highlighted this, strict scrutiny is automatically triggered whenever you take race into account. So the courts have said, we're not going to try and figure out whether it's a good use of race or a bad use of race. Race for remedial purposes, we're going to treat as Jim Crow, strict scrutiny. And again, you could ask, against the backdrop of these racial disparities, which we inherit from the past, does it make sense to treat racial remediation as suspect? The flip should be true, that if we're not drawing on race to deal with these disparities, that's suspect. Why isn't that our default? We've inherited these racial inequalities, we've never gone to zero, and yet taking race into account to address them is suspect? That seems a little bit perverse, but that's the way our equal protection doctrine works. We can think about the compelling state interest analysis and how that works. So remember, again, from law school, that the strict scrutiny regime is structured around two big doctrinal questions. Is there a compelling reason for the government's use of race? A. B. Are the means chosen to effectuate that reason narrowly tailored? We need to answer both of those questions in the affirmative to get to a constitutional moment. You all knew that. I'm sure you did. I didn't really have to reprise you. The reason I want to go there, because it's helpful to remind ourselves, particularly because affirmative action is before the courts again, what rationales were quickly dismissed in the 1970s as not compelling. Combating societal discrimination, not compelling. Well, against the backdrop of the disparities that I'm describing, why isn't addressing that compelling? Or combating underrepresentation against the backdrop of what I'm describing as racial disparities, why isn't that compelling? Or dealing with health deserts. One of the arguments that the university made in the context of the Baki case was that we need doctors of color to deal with underserved communities. Not compelling. Again, all of this you can quarrel with if you take the structural racism math that I've offered seriously. And it's a math that's kind of like 2 + 2 = 4. I mean, I really want you to fight me if I've gotten the math wrong. Another area that, again, we can talk about is the intent regime. So equal protection law is structured around an intentional model of discrimination. If you eliminate all the intentional discriminators from the United States tomorrow, you would still have excellent racial inequality because of the racial math problem that I've described. So of course we should try and identify the nasty little racist. Of course we should try and figure out whether our farmer is a cow cyst, like a racist. We want to know that. But focusing just on that doesn't deal with the toxicity in the environment any more than focusing on that deals with the disparities I have described. And there's an easy doctrinal way of managing racial disparities. We don't have to adopt the view that racial disparities equal an equal protection violation. We don't have to do that. We could say, look, you establish a racial disparity, A, shifts the burden to the government to offer some reason. That reason could be via, it needs to be a compelling reason, or maybe just a good reason, but some reason. And if you can't prove that necessity, then the plaintiff wins. Why is this a radical argument rather than a sensible one to deal with the fact that racial inequality has accumulated over time? So the takeaways, I think, are these. CRT is invested in structural accounts of race along the lines that you've heard today, including the structural racism math. Those accounts take history seriously. Taking history seriously means paying attention to the fact that racial inequality can accumulate over time and congeal in the form of the disparities that I've highlighted. This math then explains precisely some of those disparities. Legal doctrine that have equality as a mandate should be mobilized to address this. Again, why is it radical to say that doctrines that sound in the rhetorical register of equality should address inequality? Why is that a radical proposition? I don't know. None of this, presumably, is about labeling white people as bad people. None of this is about attacking white Americans or about engendering racial guilt or self-help. None of this is about that. CRS is fundamentally about transcending focuses on individual people, the individual farmer, and stepping back and thinking about how inequality travels over time. Of course, all of this should be subject to debate. I invite you to fight with me. We should argue about this. I don't think I'm the all-knowing person, that what I've said is to be taken of gospel, but nor should be the case that people who rehearse these ideas should be labeled as quote-unquote bad people, and there's nothing in what I have said, or what my colleagues have said, that should be declared illegal, that should be the subject of legislation to ban. So in some ways, I want to end by suggesting that the debates about CRT are not fundamentally debates about CRT. The debates about closing down ways of understanding race and racial inequality and politicizing an issue for obvious political gain. So clearly, we've tried to introduce some of the tenets of CRT and some of the relevance to legal doctrine. We couldn't cover the entire terrain, but I'm hoping that we've provided you with enough of a predicate for you to ask further questions and for us to have a broader discussion. Thank you very much.
Thank you so much, Professor Carbado. So I'd like to open it up. We have about a little under 10 minutes, probably 5 to 10 minutes, 5 minutes. Okay, I've been warned. So I'd like to open it up for any questions for the panelists. Okay, perfect.
Where did the term or phrase critical race theory come from? And if, as Professor Carbado says, the math doesn't add up, and that in fact it's pretty simple math, why do we call it a theory as opposed to just teaching history accurately? And to go to this young woman's point over here, just a couple of examples, and there are only a few, but I'm sure there are many. I didn't learn anything about the Tulsa riots when I was growing up. I had 2 semesters of American history, happened to be taught by a black professor who I liked very much. But I don't remember learning anything about the Tulsa riots. I don't remember learning anything about the Tuskegee experiment, and one could go on and on. I'll stop it there.
I mean, we can all weigh in on this, but so critical race theory, the term emerged in the context of students at the time thinking about the absence from the law school curriculum. My colleague Kimberly Crenshaw actually coined the term in that context. And the thinking was there were lots of different theoretical frameworks that were circulating in the context of law, and CRT emerged as a way to capture a specific intervention around race. So you could say, well, is it theory? Is it history? It's all of those things. And we didn't really have time to lay out precisely why one might call it a theory. Consider colorblindness, for example. That's a theory of race. If I were to say, imagine 2 groups of people. Group A wants to talk about race. Group B doesn't want to talk about race. And you pick group B, the group that doesn't want to talk about race. One theory about that choice is that it's racially neutral. The CRT theoretical, no, you're preferring people who don't want to talk about race. That's a different theory of understanding that particular choice. So it does have theoretical entailments, even if it's true that it draws on history as well.
Thank you, Professor. Do we have time for another question? Okay. Yes, Shana?
I thank you all so much, first of all. We need this. I wanted to just sort of ask, I guess it's sort of a combined question to all 3 of you, is how do you, or do you have tips, suggestions for in the day-to-day, how you push this, push people to think about it, to take a second and be willing to think about it in the actual day-to-day practice on the battlefield? And I guess the follow-up question to that would be, how do all of you who are immersed in trying to teach students, who I assume come from a wide range of places, how do you do this and not go crazy? The context that I'm asking this in is here in Rhode Island. Welcome to Rhode Island. We are a state where, I mean, I have to tell opposing counsel that we're going to walk out of a deposition if he uses the N-word again. I've had trying to explain to a colleague or to opposing counsel, okay, white woman to white woman, can I just mention some things that we're not taught to think about and ask you to think about them? I have had the Rhode Island Committee on Judicial Tenure and Discipline says that it is okay for a Rhode Island District Court judge, 3rd Division, if anyone's curious, to use the N-word on the bench, on the record, at my client's trial. So, to all of you, how do we teach people without catching a case ourselves? How do you all do it? And tips, please, we need them.
That might require another class, another session.
I mean, it's a hard question, and so I'll quickly say that and this is how I talk to my students about this as well, that lawyers, we are in a service profession, and part of what we develop as professionals is an ability to be witness for people, to listen, to draw out information. And so I do think that I try to always start off from a place of listening. That is, why do you think the things that where did you learn that, right? And if someone feels like they can trust me, then sometimes I can be like, can I suggest something? Do you want to read something? And so that's not a perfect answer, but I do think lawyers are particularly suited to do some of this translation work and this engagement work. At the same time, I also have some grace with myself. I cannot do that all the time. That takes a lot of emotional energy. It's work, it's labor, professionally and personally. And so I do have to think about when people are actually open. When is a space where I'm doing this work? When I'm teaching, yes. At the airport, probably not, right? And realize that me as an individual, I cannot solve the problem of a lack of openness writ large, and so I can't make myself sick trying to do that work all the time, although there are times in which I will deploy those skills, and that lawyers are really, we have those skills, we're trained to develop those skills, and so we can use them very strategically.
I think, well, I would say, I mean, I think continue to do the things that you're already doing. I would say it's really, really important. I would actually encourage more people to use their voice and speak up, particularly if you are part of the majority group or if you're white. I think it's really important and not to leave it to people of color to do it. And so I think in so many ways you have the ears of people who look like you in a way that we don't have people's ears, and people hear it differently when it comes from you and can absorb it in a way when it comes from you that they can't absorb it. So I realize that it's exhausting and you can't do it at every minute, and you have to give yourself, cut yourself some slack but I think it's also important for you to use that voice in important ways, because I think that's the one real way in which change can happen. The other thing is, I think one effective strategy is to also talk to, if you're telling somebody to talk about how you learn. When I talk to people about it, I also talk about, like, gosh, I make a million mistakes every day. I offend people. I'm learning too about this or that, and then if it doesn't seem like I'm better than you, and so I'm telling you how to be better, right? But I'm also learning too, and here are the ways in which I've learned. I think also it enables people to hear it and absorb whatever lessons you're imparting to them, and a way that's helpful, is what I would say.
Thank you so much. Thank you so much to our panelists. We are honored to have had you. Thank you.
Hello, everyone. I hope everyone is enjoying their meal thus far. I also trust everyone enjoyed their session this morning. Thank you for joining us. We're so excited for our luncheon session this afternoon. First, we do want to say special thank you to the Rhode Island Federal Bar Association for their support of the conference, as well as sponsoring the reception to follow this afternoon at 5 p.m. So at this time, I'd like to call up the president of the Rhode Island Federal Bar Association, Stephen Richard, to share a few words about the Rhode Island chapter of the Federal Bar Association. Stephen?
I promise I'll be brief because you didn't pay to hear me speak. But we are very honored to be here, and a special thank you to the court and the planning committee for putting together not only such a wonderful conference, but such a thought-provoking conference that is necessary for all of us. On behalf of the FBA, we welcome the opportunities to partner with the court. It is what makes this jurisdiction so special. I talked to my colleagues at Nixon Peabody, we're a national firm, and they cannot believe the level of interaction that we have with our bar and our court. And thank you to everyone for making that possible and for making a day like today possible. I want to conclude with just a brief advertisement. The Federal Bar Association is always looking for new members. For those of you who have not renewed your membership yet for the year, this is the time to do so. Please go to www.federalbar.org and you can easily renew your membership for the year. But more importantly, some of the newer members of the bar, we welcome your participation. We're looking forward to putting together a couple events on our own this year, And please join us and help us promote the level of interaction that we champion in this court between our bench and our bar. And we are looking forward to more opportunities to do so, and are really proud to make a small contribution to today. So thank you very much.
Do I do this? Let's see. This past year, the district court family lost one of its most beloved members, Olin W. Thompson III. Olin was to us, a federal public defender, but represented the most unbelievable values of what a lawyer in the justice system should be. And I turned to my colleague, Judge Smith, and I said, how do we honor Olin? How do we keep his memory alive? How do we bring forth the values that Olin gave to all of us in his service to the court? And Judge Smith said, we should establish an award in his name, and we should give it to somebody who lives the values of Olin Thompson. And so I'm proud to ask Judge Smith to come up and present the inaugural Olin W. Thompson III Justice Award for us.
As Judge McConnell said, we lost our dear colleague and friend Olin Thompson this year. While many of you who practice primarily on the civil side may not have known Olin well, to those of us who work on the criminal side, Olin was a real giant. He devoted the vast majority of his legal career to criminal defense work, primarily as a public defender. For 14 years, he served as an assistant federal defender in the District of Rhode Island, representing hundreds of defendants in our court. He devoted his legal career not only to representing his clients, but to the cause of criminal justice reform. Among other things, he served on Governor Raimondo's working group on criminal justice reinvestment. He helped initiate and administer our court's Hope Court, a reentry court for recently released incarcerated people. He devoted countless hours to representing incarcerated individuals who were affected by sentence reduction laws and decisions. And he was a longtime member and former chair of the Rhode Island Criminal Defense Lawyers. He served on numerous bench bar committees in our court, and in his spare time, he chaired his town's juvenile hearing board, and he judged middle and high school mock trial competitions. Olin was diagnosed with ALS in 2018, and as his condition worsened and we entered the pandemic, we still heard from Olin. He was a presence in our world as he became a court watcher on Zoom. All of us on the court would receive occasionally chats on Zoom or text messages giving us critiques or comments on what was happening in court. And Olin passed away in July at age 50, right in his legal prime. And there's not a doubt in my mind if he were still with us, he'd be sitting on the Superior Court bench today. So as Judge McConnell mentioned, as we reflected on that loss, we thought about his life of service and devotion to justice and decided to create this award in his name to honor others who reflect his legacy. So to that end, Chief Judge McConnell issued a few weeks ago an order creating this award and requesting that the District Conference Committee designate a recipient to receive the award today and at future district conferences. I want to read just a small portion of what the order says because I think it reflects what we're intending by creating this award. It is hereby ordered that this award be established to recognize and honor outstanding professionals in the legal community who serve with great distinction as a model of civility in the pursuit of justice and who have made significant contributions to the profession and to the community. Now, before I announce the inaugural recipient of the Olin Thompson Award, I want to recognize Olin's wife, Krista, who is here, as well as his sons, Olin IV, Atticus, and Nat. I'm sorry. I know that when Judge McConnell told Krista that we were creating this award, I know how she replied, how much it meant to the family, and I just think it's a great way to honor him. So now, for the award. So I can't think of anyone who is more deserving of the first Olin Thompson Justice Award than Bob Mann. Now, Bob is an icon. Everybody in this room knows him, or at least recognizes him from his frequent appearances on television and in newspapers while representing high-profile defendants in state and federal court. Some of you might not know there's more to Bob than his famous hair, his rumpled suit, and his incisive legal mind and courtroom acumen. Bob was born in Brooklyn, New York, but he grew up in Germany, and as part of a military family. And as a teenager, he not only became an academic ace, but an expert marksman. He was admitted to Yale College at 16, and then he served 2 years as a lieutenant in the U.S. Army in Vietnam before returning to Yale Law School, where he graduated in 1973. Bob served as the CJA panel representative on our court from 2004 to 2019, and on the First Circuit CJA panel. He's argued over 100 cases in the First Circuit, and he argued the case of Moran versus Burbine before the U.S. Supreme Court in 1986. Bob has received too many awards and recognitions to list them all, but two of note that I will mention. One is an honorary doctorate from the Roger Williams University Law School and the Ralph Seminoff Award for Professionalism of the Rhode Island Bar Association. Bob has devoted nearly all of his 50 years of practice to representing the poor and less privileged, and he has often been called upon to represent some of the people charged with the most heinous crimes in state and federal court. As he said when he was questioned by the press in response to a question of why he did this work when he was representing one of the most notorious killers in Rhode Island history, he said, "It is not just his rights I'm fighting for, but everyone else's as well." Bob represents the best of our profession. In our best moments as lawyers, we aspire to be like Bob. Our system of the rule of law, our state, and our court is a better place because of Bob Mann. And it's an enormous honor for me to be able to present him with the Olin Thompson Justice Award today.
Thank you. Thanks so much. Is it on?
Well, thank you very, very much. And first, I want to acknowledge Olin Thompson's family and thank them for all that you gave all of us. Olin Thompson set the standard for practicing law in this district, I think. And he'll always be remembered. And 25 or 35 years from now, when some young lawyer asks, what's this Olin Thompson Award? That'll be the segue to explain what we hope we can all aspire to. And if we can get to Olin's position, it's been a good life. So thank you very, very much. And I say to his sons, you can't fully understand what an impact your father had on us and on our clients, who knew that even if they didn't win, they'd had their day in court. And I thank you all for that enormously. I also want to acknowledge my thanks to my family and to some people who've worked with me for a long time, in particular Dana Harrow, sitting next to me. We worked together for almost 20 years, and she's about to start a new journey in her life as she becomes a professor at Salve Regina College. And I also want to thank the whole justice community. We have an unusual situation, I think, in Rhode Island where we all know each other. But I think that's for the better, and it gives us all a chance to be civil. And while at one point I thought the most important thing in the criminal justice system was the politics of the players, I now think the civility which we have and which we can pass on to others may be the overarching tone that we want. We're grateful we have that in this district. And I'm not sure we all appreciate how fortunate we are, but I want to thank the court. I want to thank the prosecutors that we deal with on a regular basis, the other defense lawyers, and I also want to acknowledge our clients, many of whom are poor, many of whom don't have benefits of education and stuff like that, but they accept us as their lawyers, and for that I'm also very, very, very grateful, and lets us practice law. And that's what we try to do as best we can. This has been already such an inspiring conference. Thank you for setting it up. I've learned so much already this morning, and I want to really express my appreciation to people like Jennifer Wood, who helps organize all this. Thank you all so much.